Hello, defenders. I am sorry not to be with you in person, but I am very honored that this year I was asked to once again give you a little snippet of information about the United States Supreme Court decisions that affect our community, thoughts about how we can use them, and thoughts about what obligations they put on us as defenders to protect children. I am once again a little bit discombobulated by the so many messages that the courts have to share. And so I was trying to think about, as I have in the past, sort of musical themes to convey them to you. And then I realized I'm distracted. I'm distracted by something personal. And now that I have all of you in this quiet, intimate relationship, just you and me and 500 miles between us and a recording that could be anywhere on the internet, yeah, I'm going to rely on you for some personal advice. Truth is, I'm in the middle of a bad relationship. Yeah, it's ugly. I mean, my lover is good to me some days, gives me things like Miller versus Alabama that says that kids are kids and that no matter what, they're going to stay kids. And you can't give them mandatory sentences like you might adults because their brains aren't finished forming yet and their personality makes them less accountable. That is love. That gets my blood boiling. But at the same time, they give me decisions that challenge the limits of what defenders should be obligated to do. They challenge the Sixth Amendment. They challenge the Fourth Amendment. Yeah, the truth is, ladies and gentlemen, I'm in a bad relationship with the United States Supreme Court. Yep, all nine of them, not even just one. I mean, I think it's all nine of them. I mean, sometimes they're unanimous in decisions that drive me crazy, and sometimes they're split in decisions I didn't think should be split. Let me give you an example. This year, probably the decision that struck a lot of us the loudest was Maryland v. King. Maryland v. King, I'm going to summarize in musical parlance as baby did a bad, bad thing. I mean, Maryland v. King says that by a 9-0 decision, that it is completely reasonable for police to take the DNA sample of anyone arrested in the United States and keep it in order to have a bank so that they can judge past crimes against it. And that outweighs any privacy interest an arrested person might have, for example, being arrested wrongly and having their DNA taken because they have no choice, and then later being exonerated. The effects of this for kids is long-term and significant, yet still, my lover betrayed me. Baby did a bad, bad thing. But then, at the same time, I feel a little, I kind of love them just the way they are when they do things like they say the Supreme Court is going to say, stop. In the name of love, stop. Courts cannot be allowed to use prior conviction details in order to increase a sentence later. It's a violation of Descamp, and by the way, it's a violation of Apprendi to turn around and say that you can convict somebody, in 1 year, and a couple of years later, the prosecution can raise facts about that prior conviction which were not found on the record to try to enhance a later penalty. I mean, my Supreme Court says it's a violation of ex post facto laws in order to use new sentencing laws that were not in effect at the time of trial but become in effect at the time of sentencing. That's a violation under Pew, and that's the kind of Supreme Court I fell in love with. But then they turn around and say, when in Johnson versus Williams, they say federal courts can't overrule a state court ruling unless the state court decided. But, if the state court issues an opinion and it leaves out an issue completely, it looks like it forgot it completely, they're going to take that silence as a ruling of affirmance of the lower court's decision. And they're going to weigh in on that decision afterwards, assuming that they are weighing in to decide whether to overturn a state court decision, an outcome that never goes well for us. It's just too late, baby, for us. And the Supreme Court's relationship, sometimes you'll meet people who say, I'm dating this dog. Well, this year, the Supreme Court really talked a lot about dogs. First, you've got two big decisions, and they go both ways, showing why it is I'm having such a hard time with my relationship. First, you've got People versus Hardinus. Hardinus says, when a dog's on a porch, Justice Scalia, the guy that I felt like I wasn't really right for, but maybe I should be dating, because he says it's a privacy violation. It's a property right violation as a trespass for a dog to be on your front porch sniffing for drugs, just like it would be if it were a person. In a 5-4 decision, Scalia took the day. Now, he didn't go as far as my, girlfriend Elena Kagan, who said it's also a Fourth Amendment violation. In fact, Justice Alito, who I have serious problems with and definitely need to break up with, said that it's absolutely not a Fourth Amendment violation, in addition to not being a property rights violation, and he was in the minority. But there I am praising my dog-loving Supreme Court when they turn around and love my dog too much when they say that a dog sniff of an odor from a car can constitute probable cause. And though the defense in front of the court proposed an 8 or 9 factor test to consider and proposed that to the Florida Supreme Court, which was accepted by the Florida Supreme Court, In a 5-4 decision, this court said probable cause, dog's enough for probable cause. If you want to challenge under all those factors, you can, but we're leaving it up to defenders. It's a defender's job to raise those questions about the quality of that evidence, just like it would be the defender's job to raise the quality of the evidence if it was a confidential informant who didn't have 4 legs and a tail. You know what that tells me? It's up to the defenders. Love's a battlefield. That's right. Pat Benatar had it right. Love is a battlefield. For example, they said in Munoz and Farmer coming out of the Seventh Circuit that mistakes that the defense made are not going to be forgiven, but mistakes by the prosecutor's office are not going to be forgiven if the defense attorneys or the defendants made mistakes first. For example, a defendant violated his plea agreement by fleeing the jurisdiction. So all bets are off for what the prosecutor agreed to at the plea agreement. In Smith, they said the burden is going to be on the defense to unprove conspiracy once it's proven. In Gully, they said once the defense opens the door for evidence that they get in for a particular purpose, the prosecution's certainly available to use that evidence for other purposes that could be detrimental to the defendant. It's really all on us. Thank goodness Pat Benatar has the best video dance, the best 1980s video ever showing us that we are in a battlefield, but we can take it. What I think the Supreme Court really needs, I mean, if I'm going to decide, am I in a relationship with Justice Alito? Am I going to be able to withstand Justice Scalia? I need to turn to the most important, love advice counselor, but also legal advice counselor, apparently, in the United States. And that's no one other than Taylor Swift. She said, I'm never, ever, ever getting back together. And you know what she tells the court to say? Never, ever, ever let the prosecution get in evidence to use for a different purpose, like they did in Richards coming out of the Seventh Circuit, where the prosecutor tried to get in evidence for one purpose and use it for another. If the defense gets it in for one purpose, the prosecution can use it for another, but not the prosecution itself. That's not going to be allowed. And Taylor Swift says no. You never get to violate the double jeopardy clause with a new trial after acquittal, even if the acquittal was a mistake. Even if the judge thought that there was a required element of a crime that turned out not to be required and he found him not guilty throughout the case, double jeopardy is going to stop them from ever, ever, ever bringing that case back. Never can you add mandatory minimums to a case without under Apprendi having a secured fact finder determination of those facts. Maybe there's hope for it yet, but the one part of my relationship with the Supreme Court I'm never going to understand is, it's hard to date somebody who never talks. There's Justice Scalia, no matter how many times, not Justice Scalia, Justice Thomas, no matter how many times we talk to him, he never talks and he never talks. But this year he gave me an inkling. He teased me. In Louisiana versus Boyer, there was a really important case about whether or not it's a violation of the speedy trial rights of a murder defendant who had to wait 4 years for a trial because the prosecution kept coming back and saying they weren't ready, and they were explaining it was because of labs and investigations, etc. And got all the way up to the Supreme Court to decide whether, when the prosecution is delayed that much, 4 years, is that going to be a violation of speedy trial? And of all the questions asked, Sotomayor was going after them, saying this is a speedy trial issue and it's important, showing all those issues. In fact, the court seemed to be going our direction. And Justice Thomas actually asked a question. I should have known it was just a tease. Because not long after the oral argument, after all of the parties had gone through all of the arguments, the briefs, etc., the court digged the case, meaning they decided that it was denied as improvidently granted. They made no decision in Louisiana v. Boyer. For all intents and purposes, the one little whisper from my ex, Justice Thomas, will never be part of the Supreme Court lore because the case is now improvidently granted and will never have a decision. It's a rough love life I have. I have Miller, and I have Miller that ends the amazing quartet of Roper and Graham and JDB. Yet at the same time, I have these difficult decisions like Henderson versus the U.S. The decision was great. It was an issue about fundamental fairness. For the first time in a long time, Justice Kagan wrote about the concept of fundamental fairness. But there, right behind her, is a dissent by Justice Alito, talking about, for the first time in a long time, ladies and gentlemen, actually mentioning unicorns. That's right. I said unicorns. He talked about unicorns in his dissent. He thought that lawyers who are seeking a fundamental fairness solution to the issue at issue in the case of Henderson versus U.S. were, quote, like a unicorn. Such a lawyer finds home in imagination and not a courtroom. How can you love a guy like that? I have to admit it's a bad relationship, right? I have to tell myself, Justice Alito, you're no good. You're no good. You're no good, baby. You're no good. I'm gonna say it again. You're no good. You're no good. You're no good. Baby, you're no good. Uh-huh. 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 You're no good. You're no good. You're no good. Baby, you're no good. But if we can do it together, we can turn him good.